My next case is Nextsun Energy versus Fernandes. Fairland Farm owns 265 acres of land off Bay Road in Norton and Easton. A portion of the land has historically been used for the cultivation of cranberries. The cranberry bogs on Fairland Farm's property were the only active cranberry bogs in the town at the time of the events at issue. Fairland Farms intends to execute a long-term lease with Nextsun, which specializes in the development, financing, construction, and operation of commercial and utility solar photovoltaic projects. Nextsun plans to use 23.3 acres of Fairland Farm property for a large-scale solar photovoltaic installation. Nextsun and Fairland intended that the cranberry bogs on this project site will remain in operation during construction. Next. The original application requested site plan approval and 2 special permits. Then in 2018, prior to the applications being submitted, there was a series of amendments which were proposed to Norton bylaws. The board held public hearings on the original application in January 2019 through April 2019. They decided the solar bylaw amendments applied to the original application, and therefore Nextsun did not require a special permit. Citizens of Norton shortly after obtained signatures for a petition to compel the town to hold a special town meeting to consider revoking the solar bylaw amendments. Next. There were some issues that were brought up to this court. The notice stated a public hearing would take place on Wednesday, December 18th, 2018, when in fact, December 18th, 2018 was actually on a Tuesday. Also, in April 2019, Nextsun filed with the board 2 plans for which it sought an endorsement as approval not required per the subdivision control law. The board endorsed the A&R plans as not requiring approval under the subdivision control law. Also, Kevin O'Neill was not a member of the board when the original application was considered, and he later became a board member. The board held 3 public hearings on the amended application. Kevin O'Neill missed one of the hearings, but he had completed a certification that he reviewed an official audio and video recording of the missed hearing. Next. In October 2019, the board voted 5-1 to approve Nextsun's application for site plan review with 64 conditions. There was a 4-2 vote to approve Nextsun's application for a floodplain overlay district special permit. A special permit requires a supermajority vote of the board, meaning the application was denied. The board issued 2 written decisions, one approving the amended project site plan with conditions, and a decision denying the amended application for a floodplain overlay district special permit. Nextsun timely filed an appeal for both decisions. Next. There are 5 issues that this court addresses. 1 was the board's public hearing on the solar bylaw amendments properly noticed under Chapter 40A and Norton's bylaws. 2 are the solar bylaw amendments spot zoning. 3 were the approval not required plans properly endorsed. 4 were certain board members' participation in the public hearings on amended application and his votes on the site plan remand and special permit remand decisions lawful. And 5 was Nextsun obligated to obtain a floodplain special permit, and if so, what was the scope of the special permit? Next. Was the board's public hearing on the solar bylaw amendments properly noticed under Chapter 40A, Section 5? A town must hold a public hearing on a zoning bylaw amendment and make a recommendation to town meeting, after which a 2/3 vote of town meeting is required for the adoption of the amendment. The board held a public hearing on the solar bylaw amendments on December 18th, 2018, and made a report to town meeting, and town meeting adopted the solar bylaw amendments by a 2/3 vote. The town met the proper publication requirement by providing notice of the public hearing by publication and posting, which satisfied the requirements. The individual residents argued they were entitled to notice of the public hearing as interested parties per Chapter 40A, Section 11, which governs notice to interested parties for public hearings for individual permit applications, such as applications for special permits, variances, and findings under Chapter 40A, Section 6. This does not apply to a public hearing on a zoning amendment. The residents are also arguing there was an error in the notice. The notice said the public hearing was going to be on Wednesday, December 18th, 2018, when in reality it was Tuesday, December 18th, 2018. The court rules here that the minor error does not invalidate the solar bylaw amendments. The SJC has ruled flexibility was necessary with respect to notice of purely advisory proceedings before a town planning board on zoning bylaw amendments, and such amendments should not be set aside because of trivial procedural defects. Here, the notice of the public hearing gave the correct date. Its error in describing the day of the hearing as falling on a Wednesday rather than a Tuesday is a trivial procedural defect that was not prejudicial. Notice here had satisfied the requirements of Chapter 48, Section 5. The individual residents claim that they did not have any individual notice of the public hearing, and this believe they violated a bylaw. The language of this bylaw is unambiguous. It provides that owners of property affected by a zoning bylaw change and their abutters are to be given individual notice of the proposed amendment unless the amendment is of universal or wide application in the town. This distinguishes between zoning amendments that are directed to a particular parcel of land within the town and those that are more general. Amendments directed to particular parcels, the owners and abutters are entitled to individual notice, but individual notice is impractical and unnecessary when the proposed amendment is a broad application in the town. The individual residents argue that the cranberry bog in town was impacted by the solar bylaw amendment change because it was the only cranberry bog in town. But the court ruled that this is a general provision that applies to any cranberry bog that was active at the time of application, and the submittal is covered by this provision. Next. The individual residents next argue that the solar bylaw amendments constitute spot zoning because they single out the project site for favorable treatment. Spot zoning occurs when there is a singling out of one lot for different treatment from that accorded to a similar surrounding land, indistinguishable from it in character, all for the economic benefit of the owner of that lot. Here, the court rules the solar bylaw amendments do not single out an individual lot for favorable treatment. Even assuming that the solar bylaw amendments single out the project site, the amendments are in furtherance of the purposes of the Zoning Act. The Zoning Act expressly mandates that no zoning ordinance or bylaw shall prohibit or unreasonably regulate the installation of solar energy systems or the building of structures that facilitate the collection of solar energy, except where necessary to protect the public health, safety, or welfare. Whether town meeting can enact the solar bylaw with the amendments with the intention of benefiting Nextsun proposal is irrelevant. A court should not invalidate a legislative decision of a town based on the alleged motive of the town head in enacting the legislation. If the action is otherwise justified, the actual reason for the enactment, not to mention the motivation of the sponsors of the action, is not relevant. Next. If the plan shows all the new lots as having sufficient frontage on the public way, a way shown on an approved subdivision plan, or a way in existence at the time of the town's adoption of the subdivision control law, then it is not a subdivision requiring an application and definitive subdivision plan approval. Instead, under Chapter 41, Section 81P, if the board finds the plan does not require such approval, it shall, without a public hearing, endorse approval under the subdivision control law not required. Having made that finding, the board had no discretion, but was obligated to endorse the A&R plans. The endorsement involved no consideration of the bylaws application to the lots, the use of the lots, or the project to be built on the lots, and the individual residents have no standing to challenge the A&R plans on those grounds. Next. The individual residents next claim that a member of a planning board may not vote on a zoning matter unless the member participated in all the public hearings on the matter. The only exception is that a planning board member may miss one meeting and still vote if the member files a written certification that the member has reviewed all the evidence received at the missed meeting. The public hearing here was not a continuance of the public hearing on the original application. The order of remand ordered Nextsun file a new updated application with the board and that the board give notice and conduct a new public hearing on the amended application. The order of remand provided that the board, as part of its consideration of the amended application at this new public hearing, could and should consider any evidence presented during the public hearing for the original application. That evidence would be presented during this new round of public hearings. This does not mean that any of the board members need to have participated in the public hearing for the original application. Here, Mr. O'Brien certified under Chapter 39, Section 23D, that he had reviewed the evidence at the missed meeting. This was all he needed to do to have lawfully voted on the site plan remand decision and the special permit remand decision. His vote was valid and does not void the site plan remand decision. Next. Nextsun's amended application for the amended project was made under the solar bylaw amendments. Those amendments remained applicable to the amended project, notwithstanding the amendments repeal, because the filing of the A&R plans froze the then existing zoning, including the solar bylaw amendments. The solar bylaw amendments added a new sentence to the end of a bylaw. As of right, siting development may proceed as an allowed use without the need for a special permit, amendment, waiver, or other discretionary approval. The floodplain overlay district includes a requirement for a special permit for certain uses. The board required Nextsun to apply for a floodplain special permit, which they did under objection. The board granted site plan review in the site plan remand decision, but denied the special permit in the special permit remand decision. The solar bylaw amendments provide that the amended project is allowed as of right. Their intent is to promote the development of solar energy generation in the town. The floodplain overlay district is intended to help prevent emergencies and reduce costs and damages from flooding. The board erred in denying the special permit. The floodplain overlay district serves important goals and applies even as of right uses within the overlay district that risk increasing floods, including the amended project. The amended application was therefore required to obtain a special permit under the floodplain overlay district. The board erred in applying the general requirements for a special permit to the amended application.